Question.
Yeah.
We are something not for the funds.
Yeah.
Because.
They have a question.
There are charities that they.
Yes.
Get around, she's gonna run the church, or so. What they
Right,
funding
yeah,
prices.
okay, I just wanted to make sure there were no problems,
Yes.
but have those. We want to. I need to just straight it. Did you push your legs?
It's, you know, no stress, the access, it's like, really it all wrong. And then they're staring all the wall, and they turn off the wall, it's like, okay, kids interested, and it's like, it's a little hard.
Oh, but you're muting. Okay, none. All right, good morning, everybody.
Good morning.
So welcome to our first of a three-part series in, I think we're calling it Living Well at Home Throughout Life. I am Joanna Stola. I am a geriatric social worker, but also a Temple Beth-El member. I'm here really only to introduce Sara, but I'll also be one of the presenters, I think, in the final piece of the series. This one is on accountable aging. In April, we're going to be doing really what should be an excellent seminar on senior scams, which I think is very, very important, especially with the rise in AI. And then our third is practical strategies for aging. And we're going to have somebody from Project Independence as well as myself. So it's very exciting. And today we have really just an incredible presenter to talk about. She's an elder attorney. I'm going to read her bio. It's very impressive. And so Judy, thank you for bringing Sara. So this is Sara Meyers. She's a member of ENIA, Scanlon, and
Siriniana.
Thank you. She joined the firm as an associate in July of 2007, and she concentrates her practice on elder law, trusts and estates, special needs planning, guardianships, and long-term care and Medicaid planning strategies, with a focus on Medicaid home care and nursing home. She's a certified mediator. She was also named to the 2013 through 2024 New York Metro Super Lawyers List in elder law. She's been certified as an elder law attorney by the National Elder Law Foundation, as accredited by the American Bar Association. She was also named the 2024 Woman in Business by 914 Inc. And I did get to see the presentation, and it is really incredible and chock full of information. Hopefully everybody has a pen and paper. Anybody on Zoom, if you want to ask a question, put it into the chat. Judy will be monitoring it. And yeah, enjoy.
Put it into the chat, nobody put it.
No, I'm sorry, the chat for those online.
If
You do not have to put anything in it.
you can say it out loud, if you have a question, just ask a question. So thank you for that introduction. Judy at Temple Beth-El, thank you for inviting me here this morning. It's really a phenomenal aging series that is going to be presented this coming year at the Temple. And I always think it's good when starting with a presentation, a series on aging, is really talking about the estate planning part of aging, because part of aging is wanting to take control. And there are many different ways to take control of your finances, of your medical health, but also of your legal health, to make sure if someone should become incapacitated or upon death or as we age, to make sure we have the appropriate estate planning documents in place. So what are some of the critical issues when we're talking about seniors and aging? The cost of long-term care, Medicaid eligibility, the New York and federal estate tax planning, and paying for care if care is needed, and sort of how to put that plan together. what are the important resources we should have in our aging toolbox as we get older. So I want to talk first about estate planning basics. What is estate planning and the aspects of estate planning? And I like to break it down into 3 different topics for the most part. Advanced directives, where you have your power of attorney, healthcare proxy, and living will, a last will and testament, and then trusts. And we're going to touch on each of those as we go through this presentation. And again, feel free to ask questions as we go along. So how many of you have been to the doctor recently or been to the hospital recently? One of the first things, other than for your credit card and insurance card, they'll usually ask is whether or not you have a healthcare proxy. So all medical facilities are required to ask you if you have a healthcare proxy. And if you say no, they're required to ask you if you want to fill one out. And when you go to the doctor, many times now when they're going through sort of their checklist, they'll ask if you have a healthcare proxy. What is a healthcare proxy? It's a document wherein you're appointing somebody to make medical decisions for you if you're unable to do so. So who can you choose? Only one person at a time. You cannot have 3 people as all of your agents under your healthcare proxy. You can have one person and then an alternate and another alternate and another alternate. So if you have 7 children, you can put all 7 on, just one at a time. But only one agent can act. You can have one agent acting at a time. It is not a group to make those decisions for you. Your doctor cannot be your healthcare proxy. Why? Because then they're making medical decisions for you in consultation with themselves. So it's important to have somebody who you trust to make those decisions for you, again, if you're unable to do so. Any questions about a healthcare proxy? So someone will say to me, so Sarah, I've signed my healthcare proxy. What do I do with it now? And I'll say it's important to make sure your proxy has a copy of it. So after you sign your documents, you'll scan it and send it to your proxy, and have each of your doctors have a copy of the proxy as well. Why do I think it's important for your agent to have a copy too? Client called me, this is probably within the past 2 months. She's the healthcare proxy for her dad. Her dad was at dinner with a woman he'd been dating and had a heart attack. Was rushed to the hospital, and the woman he was dating said, well, that's my husband. So the doctors were deferring to her to make all the medical decisions for him. They didn't say, give me proof. They took her for her word that she was the spouse, therefore making medical decisions. Because if there's an emergency situation and you're in a hospital, the spouse can make those decisions. And then the kids showed up and they were deferring to the purported spouse. And they're like, no, I'm the healthcare proxy. And it's hard to prove, like, not married, right? No one asked her for proof. So again, it's incredibly important to make sure your agent has that proxy with them as well. So when you go to the hospital, the doctor, and there's an issue, there is not an issue in terms of who's the one responsible for making those decisions. So make sure there's no questions. Any questions so far? You'll see the chat. Yes, sir.
Can the alternate be listed on the proxy or not?
Yes, so the proxy will have I, Sara Meyers, appoint my husband Kenny as my agent under my healthcare proxy. And then I have alternate agents. So if Kenny cannot act, I'm appointing so-and-so. And if so-and-so can't act, I'm appointing so-and-so. So you can go through a list, but it's one and then the next. And it's a good question. According to the public health law, which is where the New York healthcare proxy is found, it only says you can appoint an agent and an alternate agent, but we always appoint 2, 3, 2, 3, or 4 alternates, and we haven't seen an issue with that. But the statute just says a primary and an alternate, but we don't want to insult our 3 kids, so we can add more to that. Any other? Yes.
What does that mean, can't act? In other words, if Penny can't come, does that mean the alternate can show up and be the healthcare?
So that's an excellent question. So the question is, what happens if the primary agent that I've appointed can't act? So
just at that moment.
Correct. So in this day and age, there are cell phones. So the doctor should always try, and we actually put cell phone numbers on the proxy form themselves. And yes, if the doctors then can't reach the primary agent, that proxy, they should reach out to the alternate.
And that would be.
Correct, correct. Any other questions on that? So the other time, when we go to the doctor as well, they not only ask us about a healthcare proxy, they ask us if we've signed a HIPAA authorization. HIPAA is the Health Insurance Portability Accountability Act that was signed by President Clinton back in the 90s. And it has to do with medical records and security. But there's a portion of it where you can allow signing a HIPAA form, you can allow someone to access your medical records. So not just to speak to your doctors, but to access your medical records or send your medical records from one physician to another. So the healthcare proxy should be sufficient. But while we're doing that, we have our clients sign a HIPAA authorization as well, really for sort of like that ease of management, where if I have one doctor and I need my medical records sent to another doctor, I can sign that HIPAA form to allow the transfer of the records from one to the next. Or the doctor wants me to make a medical decision for somebody else, but I want to see all the records. I want to know more than just what the doctor is saying. It gives me that authorization to access those records as well. A living will. A living will is a document in New York State that's actually not legally binding, and there's no New York State statute for it, wherein you're advising if you're in a vegetative or comatose state with no chance of recovery, that you don't want heroic measures. You don't want CPR. You don't want a ventilator. You don't want artificial hydration, but you do want maximum pain relief. So this is saying if, God forbid, I'm in a vegetative or comatose state with no chance of recovery, this is what my end of life wishes are. So in New York State, it's used as evidence to the healthcare proxy and to your doctors as to what those end of life wishes are. Why do I like a living will? Because if you don't want heroic measures, and if you're in that vegetative or comatose state and want to pass, you're making that decision. So you've made that decision for your healthcare proxy. You've made that decision for your family and saying, I'm taking control. I know if I'm under this circumstance, I don't want to be kept alive. So the healthcare proxy is honoring your wishes, right? So it's not one child is saying to the other, pardon me, you killed mommy, you killed mommy. No, we're following mom's direction. And I think it's part of that being accountable and talking to your family members or your friends, whomever you're choosing, as to what those wishes are. And you are making those decisions. And in a time of crisis, you're not having other people have to think about it or contemplate it. You've taken care of it for them. Yes.
I actually had that exact situation where my mother had signed a living will with a DNR and a DNI.
Louder, please.
I'll repeat the question. Okay.
It's not really a question. It's kind of just I'll tell a short story. No one was available at that moment. And by the time they got there, I asked them, I said, look, you just have to keep her alive until we can get there, which was about an hour and a half to 2 hours. They put her on a breathing machine and took away her choice. And it became our choice. How to tell your 95-year-old dad you have to take mom off life support took a little bit of time, but we made that decision based on her choice. So that living will is really critical, although the doctor said you can make that choice because she's right there. So you're right, it's not legally binding, but it's important so that we know that person wants.
So it was not a question as you were asking, was more using that as the experience in terms of end of life care. But again, once you're saying to the doctor, though, we need dad or mom alive a little bit longer, then they're going to do those are following that, what you're requesting there. Right. So it's important to start having those conversations, right? And parents, we want to protect our children. We don't want to have certain conversations with them, but I think there also comes that point where we do need to have those conversations to make sure our kids know where our documents are. And for example, this is also my profession, but my kids know, God forbid something happens, copies of all our documents are in the den, in the cabinet. They know who to call. They also know it's my office, but they know who to call. They know where all the important papers are. In case something, God forbid, happens, they at least know where to look. Yes.
How do you handle the fact that there's always somebody who's dealing with this, or often, somebody who's dealing with this person in distress, sort of the emergency ambulance who comes? They're the people who would be putting them on some kind of ventilator or starting a procedure. How do you get the people who come through as the ambulance people to know what to do?
So that's an excellent question. So if a person has care at home and there's an emergency at home or there's an emergency at home, it's important to have, so for, that's sort of two different questions, or I'm going to answer it two different ways. God forbid if someone's having a heart attack at home and they have a living will, they're still going to be transported to the hospital because that's EMS's role. And again, when they get to the hospital, the doctors will determine if this is a vegetative or comatose state with no chance of recovery. If a person is at home receiving hospice care and codes at home, so 911 has to be called. If there is a living will, 911 won't transport to the hospital and will let that person die at home and will not do heroic measures. So they're in some ways, two different circumstances. So for example, and I actually, when you go, if you're having a medical procedure, like if you're having a colonoscopy and you have a living will, but during the colonoscopy you code, the doctors are going to perform CPR because you're not in a vegetative or comatose state. And it's something that God forbid could happen if you're in the middle of a colonoscopy. A living will is really end of life care when you're in that vegetative or comatose state. You've had a massive stroke, you've been brought to the hospital, they can't do anything for you. And again, that's why it's important to also speak with your doctors. There's a medical form called a MOLST, which talks about end of life care as well. But the living will is really that vegetative or comatose state if you want to then be, kept alive with your medical measures. Did that answer your question?
Still don't understand. Like, I don't know what could be, but somebody in the building says this person is not responding, and they come in and they see something that they don't really understand. And therefore, they're the only people addressing this situation. How do they find, or how would they expect to find information to take with that person to the hospital?
So are you talking about the EMT, whether or not they're
Yes.
going to perform CPR? EMT has to perform CPR. Yeah.
So I work in the community, and what we recommend, if there is somebody you are absolutely sure you do not want to be resuscitated, the most form, what we recommend is sort of sticking it on the inside of your front door. Or the refrigerator, because when the EMTs come in, they will look, and if the most form is up, they won't resuscitate.
Correct.
What's
So
that
that
form name?
Yeah, MOLST.
LST.
MOLS,
Correct.
which means what?
Something about life-sustaining medical orders for life-sustaining treatment.
Thank you.
And that's a medical form, not a
And
legal
they will
form.
know that's
Yes.
their standard.
Yeah, because and it's
Refrigerator or
pink,
the-
it's a pink form, so it stands out. You don't have to be on hospice, right, to have a most.
Correct, but for a living will,
Right.
if God forbid someone has a heart attack at home and 911 is called, 911 is doing CPR and or anything they can to try to revive that person. The living will is really just end of life care. We don't know when someone's having a heart attack if that is end of life or not. So I want to talk about a power of attorney. So someone always say to me, Sarah, what's the most important legal document a person should have? It's a will, right? And I always say no, right? A will, if you don't have a will, there's a statute in New York that says what happens with your assets when you pass. What's a durable power of attorney? It's a document that says if you're unable to handle your financial affairs, you're appointing someone to make financial decisions for you. I have 3 daughters. When they each turned 18, what do you think they got for their birthday? It was not a car. They got a free trip to my office where they signed a power of attorney and a healthcare proxy. True, my girls turn 18, you sign a power of attorney, you sign a healthcare proxy. Within a couple of days of that, their friends' moms call and say, Sarah, what did your kids just sign? I know they were at your office, but they all signed stuff. What did they do? And then I usually then have their kids powers of attorney and healthcare proxies. Why? Because once we turn 18, and all of us in this room are a little older than 18 at this point. Our parents, our spouses have no legal authority to make medical or financial decisions for us, right? If I call my husband's doctor, he can't tell me anything. I call my dad's doctor, can't tell me anything. We have, a doctor-patient privilege. I can't just call and find anything out. So why is it important? Because God forbid someone is in the hospital, like we talked about that scenario earlier. We want someone with legal authority to talk to the doctor. If someone doesn't have capacity, we want someone with legal authority to make their financial decisions. So someone will always say, well, Sarah, I'm married. My husband can just take care of things. So that's not necessarily the case, or wife, whatever it is. If I have a bank account in my name alone, so I have a bank account in the name of Sara Meyers, I become incapacitated. My husband has no legal authority to access those funds in that account. He is not Sara Meyers, at least the last time I checked. He can't write checks on that account. He can't make withdrawals from that account. He has no access to it. A joint account, right? If you have a joint account with somebody, if Judy and I have a joint account, either of us can access those funds. But an account in Judy's name, I am not entitled to. I can't access. So it's very important, if someone should become incapacitated, to appoint someone to make financial decisions for you. And that power of attorney should be very broad. It should have very broad powers, be able to do anything that I, when I wasn't incapacitated, should have been able to do. So then the next question after explaining the form, and so I actually think really it's the most important form. And I think sometimes people don't sign them. I have clients who are like, I'm never becoming incapacitated. I don't need this. I'm like, from your mouth to God's ears. But in the meantime, where there's the great Yiddish expression, man plans, God laughs, right? If the power of attorney should never need to be used, but in case you should become incapacitated, you want to appoint someone to make those decisions for you. And you want to be the one in control to say, okay, I'm going to appoint this person or that person. So a client will say to me, well, Sarah, who do I choose? The person that you trust. Well, I don't want to insult any of my kids. I'm like, you'll be incapacitated. It doesn't matter. And I'm not being, but it like, right? But it does, and my kids already know, right? Again, this is my profession. My kids know that God forbid I become incapacitated, who I'm moving in with, who's taking care of the medical, and who's paying for it. And they're all very young. None of them could do any of that now, but we have our long-term plan. We know exactly who we're moving in with, who's making medical decisions, and the youngest will probably be paying for it. But again, you have to start having the conversations. Oh, well, I don't trust that person. Then don't make them your power of attorney. Well, that daughter can't, gets very anxious and can't make decisions, especially if there's an emergency. That's not the child. That son-in-law, I think he's out for the money. That is not your child. You have to really know your family members or your friends if we have a solo ager. And you have to really think about, you're not insulting anyone. You're doing what's best for you. And you're taking control and saying, okay, if again, there should come a time where I can't do this, who am I appointing? Right? It sounds much more simple than it is, but these are very honest conversations we need to start having. Yes.
You've used the term incapacitated.
Mm-hmm.
Is that in New York State a legal term? Or, what does it mean? Does it mean the person has dementia? Does it mean the person broke his both arms and can't write? What does the term mean in terms of power of attorney? So
that's an excellent question. So I have a power of attorney sitting in my office now. I appointed my husband to make financial decisions for me if I become incapacitated, and we'll define that in a minute. Kenny signs it. My husband's name is Kenny. He signs it as the agent. He can actually show up in my office, well, not really, get the form and go to the bank while I'm sitting here today. So the power of attorney is valid and usable as of the date that I sign it. So for example, you're buying a house out in Westchester, right? But you live on Long Island, you can sign a power of attorney over to your attorney who can do that closing for you without even your showing up. And you do a very limited power of attorney for that. So I have capacity, I just don't want to deal with it right now. So I'm going to let someone else start doing things for me. So the form is valid as of the date both the principal and the agent have signed it. But I think your question is in terms of sort of the triggering event as to, I all of a sudden, I'm have early stages of dementia. I'm forgetting to pay bills. You as my child are gonna start to, gonna take that power of attorney, go to the bank, get your name on the accounts to start handling the finances. So incapacity is actually, is a legal definition, but you don't have to prove that I'm incapacitated in order to start using that power of attorney. So what do I do in my office? Many times we'll hold the original power of attorney for a client and we'll say either we'll release it to you when you want it. We won't release it to your agent unless either you authorize it or they give us a letter from a doctor stating you can no longer handle your financial affairs, right? So a power of attorney you can use right away, but it's not really necessary unless either you're not able to make those decisions for yourself, and that way the agent at that point is going to start using it. Did that answer your question?
Still sounds like there's a gray area, right? Because it sounds like, okay, you're gonna go to a doctor to say that person's incapacitated, can't handle financial matters. Now you have a doctor's opinion as to whether that person can, reconcile his checking account. That seems to me is, it's not a finite, it sounds mushy.
It is, because again, as soon as you sign a power of attorney, it's a valid document that can be used by the agent, right? So then the question is, when do you want the agent to start acting? Which is again, either because I don't want to be dealing, I'm in my 80s and I just don't want to be paying my bills anymore. I have capacity, but I just don't want to be doing it. So I'm giving someone that legal authority. Or I no longer have the ability because I'm no longer oriented to person, place, and time, and my agent needs to start acting. But which is why part of this is taking that control and having the conversation with your agent, with your proxies, and saying, okay, I've signed these documents. They're sitting in my desk or with my lawyer. I'm fine now. If there should come a time where you don't think I'm fine, or I'm not paying my bills, or I feel I'm not able to do it anymore, we need to have the conversations. Because the alternate to that is not signing one, and then someone becomes incapacitated and a guardianship is brought, and then you're subject to a court, a mental hygiene law, Article 81 guardianship, where there's court oversight. Right, and it's a much more expensive proceeding when it probably wouldn't have been necessary had we just had a power of attorney. But again, that's why you appoint a proxy whom you trust, and you have the conversation as to, I've signed the documents, this is when they should be used. But we'll go that around. Yes.
2 questions, maybe I'm only allowed 1.
I asked them both.
Okay, could our CPA be a given power of attorney on financial decisions?
If you wanted, you could appoint your accountant, you can appoint your dog walker, you really can appoint whomever you choose. But remember, appointing your CPA or your financial advisor, where's the oversight? Right, because now it's sort of like he or she is acting as a professional that you've hired, right, to handle your finances, your taxes, your bill paying, and then on the same stead, he's wearing your shoes and doing those things for you. So he's the professional and the client at the same time. So where's the check and balance?
If it's a trusted professional who's always supposedly had my financial well-being benefit him,
No,
it might be the best alternative, right?
But then that's a conversation. I will tell you, a lot of financial advisors, who work for financial institutions cannot do both because of conflicts of interest. Right, but again, and that's a conversation. Some accountants are willing to, others will not because of conflicts of interest, concern about accountability.
The other question was if you could define very broad power granting.
We're gonna get to that in 1 second. Yes, but there was another, read the next one, yes.
How, is there only one copy of power of attorney?
You can make many copies of one original, yes, you
You
should have
can.
one original.
And so where should the original be kept?
So that's a personal choice, you can either keep it in, where you are. You can have your agent hold it, or you can have your attorney hold it.
So you could give your attorney the original, and then if you have several people with power of attorney, you can give each of them a copy.
Okay, what you mean, several agents?
No, yes,
Okay, so I wouldn't recommend more than 2 agents, just because then you have way too many people running around doing way too many different things.
but they don't need to agree.
Well, so on the power of attorney itself,
Mhm.
you have to indicate whether or not your agents, if you're appointing more than one, have to act together, or if you're allowing them to act separately. And you can't have, so for example, though, if you had 3 agents and you wanted to sign 3 original powers of attorney, each power of attorney revokes the prior. So if you're signing 1, then 2, then 3 all at the same time, only the 3rd one is valid, because the 3rd one you've signed revokes the prior 2.
Unless they're all signed on the same document.
But that's one power of attorney appointing multiple agents,
Okay.
right? You can't have 3 powers of attorney to
Right.
3 different people.
Right.
Because again, you can't sign all 3 at the same time unless you're very talented, and then you don't need me.
So I'll read it.
Yeah, because that's really small.
Yeah, so this is related to the healthcare proxy,
That's okay.
but same idea with copies. So this person is asking if they have a healthcare proxy and they want to know that they want to know if it's okay for them to have it on their phone.
Yes.
A copy on their phone.
And I will give you a perfect example. I will tell, there are 2 people here who are my in-laws. One of their granddaughters drank too much at the prom. This was quite a long time ago. They probably don't know this, but I usually share it because I don't usually have the grandparents in the room. And we had to rush to
You're not
the
gonna say
emergency
which one.
room. I'm not saying which one. We had to rush to the emergency room because there was too much drinking, and I keep the healthcare proxy on my phone. And they spoke to me because the child, I only have, my daughter was over 18 at the time. I had the healthcare proxy on my phone. So on my phone, I have my dad's healthcare proxy, my husband's healthcare proxy, and all 3 of my daughter's healthcare proxies are all saved on my phone. God forbid something should happen. It's just, I think it's the smart, thank God with technology, we can do that. So I think it's very important if you have the person you were designated, like we talked about earlier, in terms of they should have a copy of it, so that when if there's God forbid an emergency, they're going to the hospital, they can prove that they're the one, as opposed to the woman the guy was on the date with, is the one responsible for making those decisions. So yes, I keep copies of all of the healthcare proxies on my phone. I have a file that's marked all of that. I have the powers of attorney too, but usually banks want originals. But it's just important to have those, if you're the agent, to have those documents readily accessible.
And she's fine.
Oh, yeah, she's fine. They're all fine. But again, it's just reality, right? Like, things just happen and we have to be able to talk about them and address them. Yes, and then I want to go back to some broad powers of attorney.
Someone has your power of attorney. And they say, I really don't think you're competent at this point. And maybe they really, in their mind, and they're trying to do the right thing for you, feel you're not, but you feel you are. Can you revoke that power of attorney if you have to file? What do you do?
So again, if you believe, you've appointed me the agent under your power of attorney. I want to start making financial decisions for you because I think you're no longer able to do so. So I have the original, I'm making decisions. You don't want me doing that anymore. If you have capacity, you go to your attorney, revoke it, and appoint someone else. I'm just gonna point out, I think the 3rd program you have is on senior scams. The second, sorry. One of the big issues in terms of with scammers right now is they try to have their victims sign a power of attorney to them. Which is, I just finished up I do a lot of guardianship work, and I have a subspecialty in terms of guardianships with scams. And one of the things that tipped off the family was Dad had signed a new power of attorney to John Smith. After Dad said he won the Mega Millions, because when John Smith would come to the house or John Smith's proxy, they would go take Dad to the bank. But this way, John Smith wanted dad to sign a new healthcare proxy, so John Smith didn't even have to bring dad to the bank anymore. So if you told me you're fine, I'm your proxy and you're gonna revoke it in favor of John Smith, I, as the proxy, would get very worried, which is the right response. So again, if there's a capacity issue and we're concerned someone has diminished capacity and is signing documents in favor of, no offense to John Smith, to that John Smith, that's gonna trigger a warning.
But what happens in that case?
We brought a guardianship, revoked all powers of attorney, we then sought what's called a turnover proceeding to try to get some of those funds back, and within the guardianship, the guy couldn't sign any new documents.
I didn't understand that.
Basically, if we had the person found to be incapacitated because he had functional limitations, because he was unaware that he was being scammed and giving money to bad actors. So once a guardian was appointed, he could no longer, power of attorney wasn't gonna do anything anymore because the guardianship supersedes that. And that purported, agent under power of attorney couldn't access bank accounts because they were all titled to a guardianship.
So let's say it's your child, it's meant in good faith. They say, Mom, you can't do it, and you say, yes, I can. That child would then go and get a guardianship
Well, it would
to
depend.
protect the mother whom they feel can't do it. That's what I'm.
It would depend on the circumstance, right? Like, if you feel that you're able to make your own financial decisions.
And your children think not.
Correct, right? Again, why? And these are conversations to be had. They're not taking your money, right?
No,
It's
I
not,
understand that,
it's,
but the sequence is then they would have to seek guardianship. That's all I'm.
if you're revoking, yes. So a lot of times when someone has early stage dementia, one of the issues with early stage dementia is paranoia. Right? With early stage dementia, I keep losing my keys, I'm blaming others. I can't find something, I'm blaming others. I think people are stealing my money. I think my children are stealing my money, which is not uncommon. So I go back to my lawyer to try to revoke my prior powers of attorney because I'm no longer trusting anyone. But I have a functional limitation. I don't understand my limitations. I don't understand that I'm losing capacity. I keep revoking documents. So yes, the only recourse, if the person is truly has limited capacity, is to then bring a guardianship.
Got it. That's what I want.
So, yeah, I go to write a note, write a letter, dear agent, I'm revoking my power of attorney. I want to talk about this, I want to talk about the broad powers. So the power of attorney statute is found in the general obligations law. And in it is listed the general powers that you have to handle real estate transactions, banking transactions, stock transactions, it's insurance transactions, estate actions and the like. So these are the general powers in the general obligations law. Which are usually about page 3 of a power of attorney. Then the power of attorney can have a modification section where you can add powers that the agent can have other than the standard powers. So this would be the power to gift, power to create and fund trusts, power to open a safe deposit box, power to name beneficiaries on a bank account, powers to deal with Medicaid applications with digital devices and digital assets. So the modification section is much broader than the general powers of a power of attorney to really try to encompass estate planning, Medicaid planning, estate tax planning, gifting, adding, opening bank accounts, closing bank accounts, gifting bank accounts, changing beneficiaries and the like, to really have the agent be able to do anything that you would do if you had capacity. We like a very broad power of attorney because we don't know what's going to happen. I don't know if, God forbid, I'm gonna fall and hit my head and have a traumatic brain injury and need nursing home care. So my husband's gonna need to move all my, the assets are in my name to his name, right? We don't know. I might become incapacitated and have a New York taxable estate. So I might wanna put money in a trust. I might want to move money to my spouse for estate tax planning purposes, but I can't do any of this if I'm incapacitated and don't have that broad power of attorney that does allow for gifting powers. So we want a very broad power of attorney that allows for gifting, but I will with a caveat though. When I drafted the powers of attorney for my kids, those are much more limited in scope. Because again, drafting it for an 18, 20-year-old, you don't want, I don't want Medicaid powers in there. I don't want gifting powers. I want it to be more specific because again, I know that in the next couple of years, I will update all their documents as they're, as they go through phases of life. But for them, at the 18-year-olds, I wanted it much more limited. And they just said, okay, because they just listened.
What do they know?
Exactly. So I want to move on a bit from advanced directives, which are clearly very much a hot topic, to wills. Why do people have a will? Because they dictate what happens to your assets that are in your name alone upon your death, who should receive them, who should be the fiduciary, the executor, who should be in charge of your estate, and who should be the beneficiaries of your estate. Which are the main things that happen in a will. So for example, my will says everything to my spouse. We have something called disclaimer trust provisions for estate tax purposes. And on the second to die, everything goes to our daughters. Sorry. Everything goes to our daughters. Our kids are still stupid. I love them, but we have them in trust till they get to certain ages, just because, right, they're still on the young side. We never want that to happen, right? We should all live for a very long time. When the kids were younger, we had guardians named. So I actually just redid our estate planning because everyone's over 18 now. We didn't need the guardianship provisions anymore. We updated our estate planning to just reflect that next stage in life. And a lot of younger couples, and I like talking to younger couples about estate planning, but a lot of them avoid doing planning when their kids are young because they don't want to have the conversation as who should be the guardian, because it's not an easy conversation, right? And you sort of eliminate people to then get to somebody, as opposed to saying, oh, we should all be blessed with have a lot of family members and friends to choose from. But a lot of younger couples avoid doing planning because again, they want to avoid that conversation about a guardian. And if you have a child with special needs, a grandchild with special needs, under a will, you could put provisions or a trust called a special needs trust for a child or grandchild with special needs. You can, again, limit do specific requests. Before everything goes to my kids, I want X amount going to each of my grandkids. So you have the flexibility, you get to dictate those terms. And no, you can't say, I want X to inherit only if they do X, Y, or Z. Those are not allowed. But again, yes.
If you have a will that you created when your children were born and now they're over 18, but everything else, your decision of where, like you want to pass the money to your spouse, and if he goes, then the kids split it. If those are the provisions, is it still accurate or must you create a new will?
So you don't, just because they don't need a guardian anymore, that doesn't mean you need to do estate planning. But for example, when we did our first wills, and I'll tell you, my husband and I we didn't have any, and then after 9/11, we looked at each other and like, I think we need to do this now, right? Our kids were much littler though. We had one and one on the way. It was more, let's get this done, let's pick a guardian, right? Something happens to both of us at 22, they get everything, right? Our kids then get older, right? So they might not need the guardian anymore, but we might still need a trustee for them, because frankly, if something happened to my husband and I tomorrow, we don't want our kids outright inheriting everything because they're stupid, right? They're great, but we don't want them getting three lump sum and saying, oh, I could just spend this. It needs to last for them. So I like to ladder things, X amount at 25, X amount at 28, X amount at 30. So they learn responsibility over time, but then you need a trustee. And who's going to be that trustee?
The original will.
You probably do. Again, I don't know, but these are things to look at. Or, right, we did these wills when 2 of our kids weren't even born yet. God forbid, if a child had special needs, we'd want to create a special needs trust, right, which we would then put in there. So, right, as we get older and our family gets older, our needs change and their needs change and the conversations change. Yes.
If you have beneficiaries already listed on your annuities or other bank accounts or whatever, and you forget to list one or two or several on your will, what happens?
So that's an excellent question, because it's a perfect segue, so thank you. What assets pass through a will? If you have a bank account, Judy and I have a bank account that's joint and I pass, that's not an asset that passes through the will. That passes to Judy by what's called operation of law. I have a bank account in my name alone with Judy as the named beneficiary. That asset doesn't pass through my will, it passes to Judy as the named beneficiary. I have my house in a trust. I pass. The house is not part of my will, it passes through to the beneficiaries under my trust. So what assets pass through my will? Only those assets that are in my name alone at the time of my passing. They're not joint with anyone, no name beneficiary, and not titled to a trust. So if I have a life insurance policy and my spouse is the beneficiary and I don't have any contingent beneficiaries, and if my spouse predeceases, the life insurance proceeds pass through my estate because there's no beneficiary anymore, right? Because the beneficiary named predeceased.
You had continue, you said you had continue.
If there's no contingencies.
No contingent.
Right, so if that's why it's especially like a retirement account, you have a named beneficiary, you should have contingent beneficiaries, because if spouses leave everything to each other, right, or have each other's named beneficiaries, more likely than not, one will predecease the other. So again, the assets that pass through the will are those that are in your name alone, not joint, not as a named beneficiary, not in a trust. Those are the only assets that pass through your will. So in the olden days, they used to call it a poor man's will. What was a poor man's will? Everything having a named beneficiary. So then you wouldn't need, you should always have a will, but you wouldn't need to probate the will. Yes, any questions on that? So my next thing is, what happens if you die without a will? What do you think happens to your money? See, it doesn't.
It goes to the closest relative.
Yes, so many people think that when you die without a will, the state takes your money. Maybe under the maybe under the New York City mayor, but not in terms of New York State statute. If you die without a will, the state does not get your money. There's a statute under the state practice laws and trust and laws that says, if you die without a will, we look to see who your distributees are. If you have a spouse and no kids, everything goes to your spouse. If you have a spouse and kids, the first 50,000 goes to the spouse, and then the spouse gets 50% and the kids get 50%. If you have no spouse and kids, it goes to the kids. If you have no spouse and no kids, they look to see if you have parents. If you have no parents, they look to siblings. So there's a family tree of what are called distributees, and it just goes statutorily to those individuals. So you have no control, right? If I pass without a will, my kids get everything, once they're over 18, they just get everything. We can't have it in trust for them. It doesn't name a guardian. If I have a child with special needs, it doesn't bring that into consideration. It doesn't help you do any estate tax planning. So yes, the government doesn't get your money, but it goes to what are called your distributees. So you have a beneficiary under a will. If you don't have a will, they're known as distributees, and it goes to your closest distributees. So this is my favorite. At least once a week, I'll have a new client who'll come in and say, Sarah, I need a trust. And I say, okay, why do you need a trust? Because my neighbor has a trust. My son told me I need a trust. My friend has a trust, I need a trust. I say, okay, why do you need a trust? I don't know, I've been told I need a trust. What kind of trust do you need? Sarah, I just need a trust. So what is a trust? A trust is a piece of paper. It's all that it is. It has a lot of legalese on it. So what are there three main type of trusts? A revocable trust, an irrevocable trust, and a special needs trust. There are many, many more trusts than that, but those are the three main types of trusts. A revocable trust is a trust that's in my name. I still own all the assets. The assets are still mine. I still have all of the control. I can revoke it at any time. So Sarah, why do I need such a trust? Some people prefer for ease of management and privacy to have all assets titled to their revocable trust, so that upon death, you avoid probate, you don't have to pay your $200, you avoid probate. Your successor trustee after paying all expenses can distribute the assets. So there's privacy there, because when you probate a will, the surrogate's court files are all online. You can Google web surrogate, put in a county, put in someone's name. You can see their estate, their will, their probate petition and the like. If assets pass through a trust, you don't have to go through the surrogate's court. You have privacy and ease of management. So that's for the most part why people use a revocable trust. So someone will say, well, Sarah, if all my assets are in a revocable trust and I have a New York estate tax, does that avoid paying an estate tax? The answer is no. The estate tax is based on the assets in your name at the time of death, be it in your revocable trust or passed through your will. A revocable trust is not estate tax avoidance. So it's really used for ease of management and for privacy. Yes.
Can you also do TOD on your major brokerage accounts so that you don't have to do the living trust?
So that's like what we talked about earlier. So with our bank accounts or brokerage accounts, if you have a named beneficiary, it could be transfer on death, named beneficiary, pay on death. Each financial institution calls it something different, right? Those avoid probate, and those are just have named beneficiaries on accounts. But sometimes for ease of management, someone wants to have everything titled to a trust, right? Because let's say you have 5 bank accounts or 7 bank accounts, and each has a little over $1 million in it. And each of those 7 bank accounts that with a little over $1 million each, all has a different named beneficiary. You have a New York estate tax, because the New York estate tax is for estates over about $1 million. How are you getting all these 7 beneficiaries to pony up their share from their accounts for the New York estate tax? Right? So if I have all my 7 accounts titled to my trust, each, with name that, each, like, I can then have a specific bequest or saying, each account could go to these people, but at least first I can pay the New York estate tax from those funds. And who's paying the bills, right? Upon death, there's still bills. You're having 7 accounts go to 7 different people who are paying all the bills from the estate. So that's not really the best way to handle things. So in terms of the revocable trust, people really use them for ease of management. So that way upon death, upon my death, my accounts are frozen, right? And they can't be accessed until my will is admitted to probate and I have the executor able to act. That could take 3 or 4 months. So if my assets are in a trust, upon my death, I have a successor trustee, and that successor trustee can act right away. So we don't have a gap in time. Did everybody follow that?
So you're saying that the trust would pay the taxes on it, and then, so let's say it would be 30% is the tax, then the trust, then the the beneficiaries would receive the other 70%.
So that happens for an estate. If there's an estate tax, the payment comes off the top, and then the beneficiaries, get the net estate after all expenses have been paid. That makes sense?
Yeah.
Okay. Yes.
So you have a large TOD account with multiple beneficiaries. Before that one account gets distributed to them, the tax gets paid?
It should.
Okay.
But it's harder who's in charge of doing all of that. Right? And you want to make sure that gets taken care of. So I don't think if you have significant sums, the way to go is to have multiple bank accounts with multiple named beneficiaries. If you want to have that ease of management, either have it, all titled to a trust with the beneficiaries or have it pass through a will. Yes. Oh, I thought you were raising your hand. So revocable trusts are really just used for ease of management. There's no estate tax benefit. There's no Medicaid planning benefit. It's ease of management. Is there a question? No. Then many people use irrevocable trusts, known as Medicaid Asset Protection Trusts, to start protecting assets from the cost of long-term care. Why? Why do people do Medicaid? Some people do Medicaid planning. If I have a good slide here. Yeah, here. Care in a nursing home right now can be close to 200. This is even out of date at this point. No, about $200,000 a year. There was a great song from the 70s that I won't sing for you, but it was, if I had $1 million, I'd be rich, right? Not anymore. Care is incredibly expensive. So many people especially if later in life they can't get long-term care insurance, they will create a Medicaid asset protection trust to start protecting assets from the cost of long-term care. Because once an asset is in that trust, after 5 years, it's fully protected for Medicaid purposes for nursing home Medicaid eligibility. So if I transfer my $1 million brokerage account into my Medicaid asset protection trust, after 5 years, that $1 million is invisible for Medicaid purposes. The problem is, once the money's in that trust, I have no right to it. I can no longer access those funds. So I can't use those monies anymore. So again, a lot of people don't want to put significant assets into the Medicaid trust because again, once the assets are in the trust, I can no longer access them, but I can protect them from the cost of long-term care. So it's a double-edged sword because I'm doing the Medicaid planning to protect the assets, but once again, they're in the trust, I have no ability to access those funds. But again, it's a good way to start protecting assets from the cost of long-term care. Many of my clients like to put their house, their co-op, their condo into a trust to start protecting some assets from the cost of care. But again, once it's in the trust, you lose control over it, unlike a revocable trust, where it's still your funds and you can be the trustee and you have full access. With the Medicaid trust, you can't be the trustee and you cannot access those funds. Yes,
Can anyone access those?
your trustee can.
So if it's your spouse, then your spouse or your children.
Your spouse can't be, it's for Medicaid purposes, it doesn't work if your spouse is the trustee because spouses are legally obligated to support one another. So they would have the obligation to use those funds.
So basically, you're trusting your trustee to take care of you because they have access to the funds.
Right, so we have a provision where the trustees can pay income out or principal out to beneficiaries other than the grantors, other than mom and dad. And then who they're paying it out to can funnel money back to pay for things for mom and dad.
So you can still remain in your house and pay your taxes and whatever, because your trustee is accessing the money and paying those bills for you.
Correct. Well, in terms of the house, we have a provision in there so the kids get what's called a step up in basis on death when they inherit the property, that you are still responsible for all your property taxes and all the maintenance on your house. That comes from something other than the funds in the Medicaid trust.
But, okay, so it's not the house, but you're trusting your trustee to basically take care of you once you have that agreement.
You're trusting the trustee to protect the funds in that trust. And there's like a backdoor provision that if you have no other funds, the trustee can invade the trust for a list of beneficiaries who then can pay for things for you. Nothing can go directly from the trust to you because it's an irrevocable trust. And the point is to show Medicaid that I've made a gift to this trust and I have not received any benefit from it.
Does everything you have to go into that trust?
No. So for example, there's that 5-year look backs. We talked about assets in the trust for after 5 years are protected. But I'm a healthy 80-year-old. I don't want to put all my assets in a Medicaid trust because I still want to live and travel and go to the theater and I have expenses. So some people will take some assets. Like I have clients who will take their house or their property and 50% of their non-retirement assets to put it in the trust to start protecting some assets, knowing they have some liability. But not everyone's going to need nursing home care. Not everybody's going to need home care, but at least we're protecting some assets from the cost of long-term care, right? Nobody knows when they're going to get sick, if they're going to get sick. So clients will say to me, so Sarah, do you have a Medicaid trust? I'm like, I'm just in my 50s. Like, I'm not doing Medicaid planning now, but it's something that I will look into when I'm older. But again, so when's the right time to do a Medicaid trust? And it's a very personal choice. I have a client who's in her 40s. She and her husband came in not that long ago. She has dementia. It's early onset dementia. We did Medicaid planning for her because she was in her 40s, knowing that within the next couple of years, following her siblings' trajectory, she was gonna probably have full-blown dementia and be in a nursing home. And it was very clear that this 40-something had significant cognitive decline. So do I recommend most 40-somethings do Medicaid planning? No. And not all 80-somethings need to do Medicaid planning or want to. It's a very personal, specific choice. And others like, you know what? I need care, spend it, spend my money. My kids don't need it, just pay for my care. So it's a very personal choice, as with all estate planning, of what type of planning we want to do and when. And I just want to hit the end. We're not gonna. Why it's important, let's just talk about some of the key takeaways. It's important to start having the conversations, right? With your parents, with your children, with your spouse, with your partner, as to what aging is going to look like. But I think this is really for anyone, couples in their 20s, 30s, 40s as well. Having advanced directives, taking control of who's going to make medical decisions for me if I'm not able to do so. Who's going to make financial decisions for me if I'm not able to do so? Where are my accounts, right? God forbid there's a medical emergency and I no longer have capacity. I don't want my kids running around crazy, not knowing where my documents are. Our kids don't need to know how much money we have or what our investment strategy is, but at least they should know where the documents are and who to call. Have a list. Who's your lawyer? Who's your accountant? Who's your financial advisor? Who's your doctor? Who are your multiple doctors? At least this way, if God forbid there's something, your fiduciaries know who to reach out to. It's not like they're starting from scratch. So it's just important to have that all in a row. There was a point in the 80s where if you opened a bank account, you got a TV, a toaster, whatever it was, you don't need all those accounts anymore. How many bank accounts do you have? Start consolidating, right? Make it easy. You might have forgotten about accounts. There's the New York State Office for Unclaimed Funds. You can Google it. Put your name in. You'll see if you have a bank account that's been dormant. And if you haven't accessed that account in 3 years, it's escheated to the state. And then you have to go claim it. I have a brother-in-law who periodically puts his name in and then will let my husband know when he found something under Sadanoff, right? To just see what's out there. So go to New York State Office for Unclaimed Funds. It's easy when you have an uncommon last name, but make sure you know where those accounts are. Make sure if they're there, go get them. It was great. He found we had, Tiffany credit from when we got married that we forgot about because it was paper, and then we got gift cards from Tiffany's afterwards. So again, always good to check to see what's there. Let somebody know, again, as I said earlier, we have a cabinet in the den. The kids just know it's actually where our cemetery, plot deeds are. It's where my dad's cemetery plot deed is, right? It's where our documents are. It's where copies of our tax returns are. So at least they would know where to start and start having those conversations. Why? Because it's important. If we're going to demystify it the same way kids in high school start learning about financial responsibility, it's important to start learning about legal responsibility as well. And it's, I think, a good thing to have these documents as opposed to continuing to avoid them. And also check your retirement accounts. Make sure they have named beneficiaries, contingent beneficiaries. Also, if you had a 401k you rolled over into an IRA when you left that job, make sure that the beneficiary didn't roll over. If you moved it from one financial institution from another, or one financial institution bought the next financial institution, make sure those beneficiary designations are there. Any questions as we wrap up? Right, we're running late already, so I apologize.
I have a question for you.
Sure.
Moving back. I have no parents. The only relatives I have present that haven't spoken to in like 40 years. And then another cousin who's not the first cousin, but it's the only at this level alive. But like the kids I've named in my will, but how does the state find these people that are related to that may not be named in any of the documents that I've done?
Okay, so I'm gonna rephrase that a little
Okay.
bit if you
You
don't
know what I'm
mind.
trying to ask?
So the question is, I'm a solo ager. I don't have in the immediate family, but I have more extended family who are named in my will. I actually first always tell solo agers, don't have a will, put everything in a trust, but we'll explain why in a second. So when you die and your will is admitted to probate, I decide not to leave anything to 2 of my 3 kids. But my kids are don't worry, they're all taken care of. I decide not to leave anything to two kids, I leave everything to only one of my kids, because everybody knows she's my favorite. When I die, my will's admitted to probate.
It's being recorded.
It's okay. When I died, my will's admitted to probate. All of my children, who are known as my distributees, are noticed and have to sign what's called a waiver and consent, agreeing to have my will admitted to probate. Or they don't sign that and they can file objections to the will, saying mom had there was undue influence, lack of capacity, or whatnot. So if you leave nothing to your kids or whatnot, if they're your distributees, they are noticed upon the will being admitted to probate. If you don't have spouse, children, when your will is being sought to be admitted to probate, your closest distributees still have to be noticed to sign a waiver and consent. So it's sort of like the rules of intestacy. So if you have no spouse, no kids, if your parents then are your distributees, so they would have to sign the waiver of consent. If your parents predeceased, your siblings are your distributees. If your siblings have predeceased, it's their children who are your distributees. If you had no siblings, you're an only child, then your first cousin, your aunts and uncles are your distributees. To avoid that issue of finding relatives who the estate, who your executor is responsible for finding, not the state. They have to hire genealogists sometimes, like I have clients, they came over for Ireland, they left family, they had this, it could be very cumbersome. The way to avoid that is have all of your assets titled to a trust. So then upon your death, your trustee or successor trustee has your beneficiaries, distributes, there's no probate, there's no notices. But again, your successor trustee, like the agent under power of attorney or your nominated executor, they should really know. You need to start having those conversations. And if you came to me, for example, and you wanted to do a will, we would do a family tree to make sure that we know who your distributees are for ease of probate upon that time. Like it would be irresponsible of me to not find that information out from a solo leader.
I guess part of what I was saying is the one that I'm in contact with, I don't mind. The one that I haven't spoken to in years, I don't feel I lost touch with them and not from my doing. Why
Right.
should they get anything
They're
at
not,
this point?
you don't have to leave anything
Right.
with them, but they are your closest distributees, so they would be notified that the will is being admitted to probate. So if you want to avoid that, have everything titled to a trust.
Okay.
There was other question, there was one.
If
I
a
got
house is in a revocable trust,
I'll think about
then
that.
you want to sell the house, how does that work?
So it's the house is in the revocable trust, your trustees, which is a revocable trust, you're probably the trustee. You as the trustee or your trustee is the seller. So Sara Meyers as the trustee of the Sara Meyers Revocable Trust is the seller of that, as opposed to just Sara Meyers. Any other questions? Yes.
Can we get a digital copy of this to the?
I'm gonna send that, I'll send it with the recording.
Thank you.
Excellent. Thank you.
Thank you. So thank you for spending your morning with us.
Thank you. Thank you. I'll make it out tonight. You have a business phone?
I do, and thank you to Temple Beth-El for arranging this. I think these programs are incredibly important and really good questions to be asked and conversations to be had. Sarah's been since now. Well, we were friends first, actually.
I'm there, I got Kenny.
I think I'm I have heard it, forget it, but just let's go, I had this allowed.